All right, well, welcome everybody. I don't want to waste any time jumping into this TA session. I am Melissa Moorehead. I work with the Michigan Public Health Institute in partnership with the Illinois Public Health Institute on a project, a program office called Data Across Sectors for Health. It's funded by the Robert Wood Johnson Foundation that is also a funder of the Network for Public Health Law and is a natural overlap with the mid-states region of public health law. If you haven't seen this map yet, this TA session or Q&A session is moderated and being answered by attorneys from the mid-states region, which has a specialty in public health data sharing and legal issues. So we have a number of different ways to ask you to engage with the panelists. We are going to ask you to enter questions into chat if you are comfortable having some back and forth with others on this call, as well as some of the presenters. You can ask a question semi-anonymously through the Ask a Question poll that shows up in the poll section of your Pathable screen. And we are asking you to go ahead and raise your hand if you'd like to have a little live interaction. So that said, we will be collecting those questions and presenting them if you don't feel comfortable asking on your own. And we will also be collecting them and have an opportunity to extend the conversation through a data law group at All In Data for Community Health, which we'll talk about just a little bit more later. So that said, I am going to turn it over to Carrie Waggoner, who is an attorney at the network and who will also be helping moderate our questions.
Thank you, Melissa. And if we could advance to the next slide. So as Melissa said, I am a senior attorney here with the network's mid-state regions, and I'm really glad to be here today. Just a little bit about the network. The Network for Public Health Law is a national program that's partially funded by Robert Wood Johnson. And the network promotes and supports the use of law to solve public health problems. And our work includes providing legal technical assistance, training, and presentations to attorneys, developing tools, and sharing data, meaningful data to improve health of communities in compliance with the law. And just our disclaimer here, this is not legal advice, this is an educational presentation and dialogue, and so for specific legal advice, please contact your attorney. So with that, I'll turn it over to our regional co-director, Denise Chrysler.
Hi, everybody. Thanks for attending today. I am Denise Chrysler. I am the director of the Mid-States region of the Network for Public Health Law. We're located at the University of Michigan School of Public Health. I've been in this position for 10 years since the network was launched. Prior to that, I spent 27 years providing legal counsel and representation to the Michigan State Health Department, and my work included public health authority, communicable disease, a lot of issues on data, environmental hazards, and emergency preparedness and response. And I don't think I need to tell you that these are unprecedented times, not only with regard to a pandemic, but with regard to law. I don't think I have ever faced this many or examined this many complex legal issues. And Peter and I do training with regard to public health authority, and we found a useful approach that is depicted by this slide and just breaking down the issues, and it works well in routine times and especially in times such as this. So we first asked the question, if a governor, a state health official, a local health official, a local unit of government is looking at taking an action to address an emergency, the can I? It's mostly a legal question. Do I have the legal authority to act? If I do, what are my options? Who else has legal authority, and how does that all intersect? And then the must I, this is mostly also a legal question. Does the law require that I act? If so, must I act in a particular way? And then finally, the should I, and this is where most public health actions come down to. I have the authority to act. I'm not mandated to act or act in a particular fashion. So how do I exercise my discretion? And the should I involves both ethical and policy considerations. We find this approach useful whether we're looking at the authority to collect or disclose information, or to issue stay-at-home orders, mask orders, or other types of orders, and hope you find it useful too. With that, I'll pass it off to Sallie.
Hi, everybody. Great to be here with you. So I'm also with the Mid-States region. I'm a deputy director, and I've been with the network since January of 2019. Before I joined the network, I worked for West Virginia state government for, I think, 26 years, and I was the chief privacy officer for the executive branch, and really enjoyed working with agencies around HIPAA compliance and risk management, as well as a whole host of other privacy laws. So glad to be here with you today. And we're going to be talking about, or really, I guess, responding to your questions primarily around data privacy and information sharing. And so for public health provides patient care in its clinics, but it also protects the population, and it protects patient privacy, but then has a competing obligation to keep the public informed. So privacy is a real balance, and trust underscores everything that public health does. So I'm looking forward to a real robust discussion with you, and hope to answer all of the questions that you have today. So in a minute, I'm going to be passing it over to Peter Jacobson, and he's going to introduce himself and then get us started with a little bit of a hypothetical. And I'll pull up Peter's slides right now. All right, Peter.
Yeah, thanks. Hi, everyone. Thanks, Sallie. I see some familiar names on the list so far. Pleasure to have the opportunity to talk to you again and go over some of these important issues. I am the principal investigator and co-director for the Mid-States region. I recently retired, well, actually not so recent, 3 years ago, from the University of Michigan School of Public Health, where I taught public health law and health law for 21 years, along with an assortment of health policy, public health policy courses. Sallie's term hypothetical is a bit of a misnomer. We're using an actual technical assistance request to introduce the confluence between data privacy, data protection, and public health authority. And I'll be explaining the nature of the request along with how we handled it. And this was a reasonably collective endeavor for the network of Mid-States region, which is how we like to operate when possible. And you know, I'm curious to see if you think we reached the right result or whether there were better options than we considered. So the initial request was from Michigan County Health Department asking whether it would be appropriate to issue a press release indicating that some individuals who had attended a party, and this is the important part, on a specific date at a specific address may have been exposed to COVID-19. So our conclusion is, or was, that there are no legal barriers to issuing the proposed press release. Instead, to us, this was a policy question within the health department's discretion. Next slide, please. And so to show you how we reached that conclusion and why. And again, really using the template that Denise just articulated. But some of the details are significant here. And the first one is probably the most important. The host refused to cooperate. The health department questioned the host, asked for names of attendees, and the host refused. Now, are there actions the health department can take against the host? Probably, but what the department decided to do was to issue a press release, as I mentioned, with the specific address and date of the party, where 20 people had attended the party. The infected person does not live with the host. He or she was one of the guests. And so the department was exploring really two options: issuing a press release or obtaining a warrant. So they asked for the TA, and looking at the template, must I? No, there's no requirement under Michigan law to issue a press release. Can I? Oh, I left out a word. Can I? Yes. The local health department has the appropriate authority. But the key, as Denise mentioned, and where most of the requests have fallen, is should I? And it's a tough call for the reasons that we'll get to in a second. Next slide, please. Thanks. So first, what are the legal issues? Ordinarily, health departments are obligated to protect the privacy and confidentiality of data that they collect. But the Michigan Public Health Code allows release of public information connected to an investigation if the department determines that it's necessary for protecting the public's health. In this case, it was clearly connected, the information collected was clearly connected to an investigation, and the determination, the decision is whether it's necessary to protect the public's health. Had the host cooperated? Probably not. Would have been handled privately. But the host, as I said, didn't cooperate. Are there privacy confidentiality barriers within the code? Yes and no. There's certainly a broad authority under the Michigan Public Health Code and most other state codes to obtain private data for the investigation. And there is an expectation of avoiding public disclosure whenever you can. So I think the default option is certainly to protect the privacy. But there's a subsequent section of the code that allows epidemiological information available to public inspection when the health officer determines, again, the necessity to protect the public's health. Unfortunately, the code doesn't really provide much guidance, either in defining what public inspection means or what criteria should be used to allow public inspection. Absent a definition, well, clearly the address alone constitutes epidemiological information. But next slide, please. We determined that based on sort of a default analysis, that public inspection would allow the department to release the information. Then the question becomes whether HIPAA would be a barrier. I think it's clear that the address would constitute protected health information, PHI. Nonetheless, under the public health exemptions, disclosure would be permitted, once again, same language, if necessary to avoid a serious threat to health. I would certainly argue, and we implicitly argue, that allowing an unidentified person to spread COVID-19 would constitute a serious threat to health. Therefore, HIPAA is not a barrier. So we get to the crux of the matter, should I? And these are, as Denise alluded, policy issues. And here's where we expanded the analysis. There are several questions that the health department should answer or address in looking at a press release. And there are guidelines from an ASCO, NACCHO, public health, ASCO, NACCHO, and the Association of Healthcare Journalists developed guidance regarding the release of information. And I can send you the link if you want it. It's fairly general, but it asks a series of questions. Has the department documented the factual analysis? Yes. Who at the health department formed a good faith belief that the information based on professional judgment and discretion should be released to protect the public health? And does state law provide a more stringent standard? So looking at all of that, and importantly, the nexus between the information to be disclosed and the action to be taken by the recipients, those who are exposed at the party, to avoid harm. And I think there's a clear nexus here between the notice of the exposure and my ability, if I'm one of the attendees at the party, to do something about it. Even though we know there's no extant treatment, I'd be better off getting tested and followed than not. Next slide, please. So under normal times, in normal times, a press release would be desirable. I tend to be fairly aggressive in advising health departments on public health code interpretation, but these aren't normal times. Given the threats and the attacks on public health officials, we advised the need to proceed with caution. It wasn't our decision to make. We basically said in response to the TA, you have the discretion, you can do it, but you really need to think about whether there are alternatives that you could use to prevent the specification of the time and address of the party. And is there a way to release the information, as another local health department did, without any specifics, and let the attendees figure it out? It's not ideal, but at least it doesn't expose the health officials, the chief health officer, to the kind of attacks we've seen in other jurisdictions. And maybe you want to go and get the court order or a warrant. In some, we said, you can do it. Whether you should do it ultimately is something you have to decide. It wasn't our job, our place to tell you how to proceed. So that's how we handled it.
Thanks, Peter. I'll get the other deck back up here. And pass to you, Melissa.
Great. Well, thanks to all of you for giving us a little introduction and a nice example of the kinds of questions and response that we can get to on this call. So I don't want to take too much time before getting to questions. Just as a reminder, different ways that you can participate. I hope we haven't made it too many options, but in the center of your screen, where you're looking at the video, there should be a little raise hand feature. You can raise your hand and we can unmute you if you'd like to ask a question live. You can use the polling feature that is part of the Pathable screen to enter a question that the speakers will see, and we will address them out loud as well. So Sallie, we went back to your Okay, thanks. You can also put the question in the chat for this session, and we'll read it out loud if you aren't, if you are unable or don't want to say it out loud. Again, I love the Network for Public Health Law and their mission of providing assistance to people around public health. The attorneys have provided here their contact information. It is an ongoing project. So you will have continued or ongoing opportunities to connect with the network. You can join the network by, there's a link on the slide that you'll get when the slides are uploaded. And you can also join a community called All In, Data for Community Health, where Sallie moderates a group called Data Law, and there's some peer technical assistance and also some valuable technical assistance directly from Sallie there. So that all said, if you have located the polling option, we did ask a couple questions just to get a sense of who's in the room. And it does look like the majority of respondees are attorneys, which is great. Helps to know what level we're dealing with. And then we do have a fairly broad swath of states, people who work in different states, a couple from Indiana, 2 from Michigan, and then Minnesota, Tennessee, Virginia. Those are, might have an impact on how your question is answered. So you might want to identify what state you're asking about if you do have a question. And it looks like by and large, we're all from states where we are at least moderately satisfied with our state's public health response to COVID-19. So that said, I am not seeing any questions in the chat yet.
Melissa?
There is one.
Yes.
Yep, this is Carrie. Is my audio better?
Oh, your
Yeah.
audio's great. Thank you.
Excellent. I think my neighbor weed whacking was an issue. We do have one question. It's how do you think the Supreme Court will address police power cases as the pandemic drags on?
I'll start. I think it's mostly going to be state Supreme Courts handling these cases, although the Pennsylvania case that Lance Gable talked about in his session could well make it through the federal courts. Leaving it with the U.S. Supreme Court, my guess is the court will want the appellate courts to handle this first and only enter in as a last resort. In the end, I have a feeling that the court would place restrictions on the duration of time. That is, I don't necessarily expect the U.S. Supreme Court to unilaterally constrain public health practitioners, but I would expect that the court not to allow unlimited stay-at-home or other restrictions.
This is Denise. I'll jump in too. And I remind myself that Jacobson versus Massachusetts from 1905 was a US Supreme Court case. So there is the potential, I don't know the likelihood and when that would occur, there is the potential in doing the balancing of civil liberties and the common good that the Supreme Court could start weighing in and rendering a decision that fleshes out the issues in today's modern world. I agree with Peter in the sense that the longer this goes on, the people's tolerance and possibly the justices' tolerance wanes, but it's not like the pandemic and the threat of COVID and the effects of COVID have become less problematic, less serious. That remains. If the U.S. Supreme Court does follow Jacobson and does not undermine it, reasoning. I would believe that about all actions by governors and by state and local health officials, depending on what the statutes say, would be upheld, simply because if you look at the, the public health necessity of the action, and that was one of the Jacobson standards, and then you look at, is this a reasonable means? You look at the proportionality. Some would argue concerns about whether the remedy outstrips the harm, and then the harm avoidance and the focus of the remedies on actually reducing harm. So granted, I'm a little biased, but I would think that most public health actions and governor's actions would prevail.
Great. Well, Sallie, if do you want to chime in on that at all, or?
No, I tend to work only in data, so I rely on my colleagues within Mid-States to address all of the other areas in public health.
All
Thank
right.
you.
Great. Well, Carrie, I am not seeing any chatted.
Can I add one thing?
Oh, absolutely. Please do.
I agree absolutely with Denise's analysis. I think the broader question that's likely to go before the court is really whether the court is going to take a step back in time. Lance, in his last session, made the point that the district court judge overturning the state of Pennsylvania, Commonwealth of Pennsylvania's stay-at-home orders, business restrictions, etc., basically made for all the lawyers on the claim, on the call, a pre-Lochner decision, basically looking, or a Lochner-like decision, a pre-New Deal decision. And I think there are some justices on the Supreme Court that would take an opportunity to limit the scope of government if given the right case. So while I agree with you, and I think the court will uphold it, it's not a done deal given the current composition of the U.S. Supreme Court. For those in the session, any thoughts about how we handled the technical assistance claim? Are there better ways of handling it?
That's the case study that you shared earlier.
Case study, sorry. Yeah.
Hey, Peter, this is Sallie. I don't know how viable this approach might be, but it would certainly provide privacy. What if the county health department had published a legal notice or some kind of notice in the paper that said a party was held on such and such date and indicate that it occurred in the county and to call a certain number. And then they could have people call that number and then screen the callers if they provided the host name or the street address. Is that an option for public health?
I don't see why not. If you can issue a press release, you ought to be able to issue that kind of notice. What the other county I mentioned in Michigan did in response to a similar situation was close to that. It just issued a notice without even specifying the date, saying there was a party and there was an exposure If you think you might have been exposed, call this number. So they were very close to your suggestion. The only difference being the absence of putting in the date.
And Peter, I recall on that other situation, people figured out in the community whose party it was. And
Yeah,
it depends a
yeah.
lot on, and it's sort of,
Right.
it depends a lot on how big of a community you
Yeah.
have. And you can mention it was a graduation party and that sort
Right.
of thing. But if you have a big city and you have lots of gatherings, it's pretty hard to effectively warn people that they need to quarantine.
Well, and particularly if you don't have cooperation from the host, but even in the one you mentioned, we were talking about, there was some pushback. The people were blaming the host for it, and that's what the county, which contacted us, was worried about, exposing the host to threats. We expanded that exposure to say there's a possibility that health officials would be similarly attacked or threatened.
In my city, I'm in Ingham County, Michigan. My local health officer went way beyond what our governor did, and she dealt with the university parties recently by by issuing a quarantine order against 30 properties, sororities, fraternities, cooperatives that had parties and had exposures of individuals, people who had tested positive. So she just quarantined them all for the next 14 days. And hopefully there'll be cooperation so that the quarantine isn't extended, but that's how she dealt with the issue.
Right, and she didn't even need to use the executive order to do that. She could have just used the public health code.
Yeah, that's what she did do, is
Yeah.
use the public health code.
Yeah.
So I actually had a question and building in my mind about the differences between the way public health is structured in different states.
Yeah.
So are we talking, how specialized are we talking in any given situation? Could any local health department officer in the United States exercise similar authority? Or does it depend on the way the state manages their public health system?
Well, it depends. This is Denise. It depends on how public health is structured in the state, how the governor's laws are, or how the governor's powers are described, how the state health officials' powers are described, whether it's home rule state who has police powers at the local level, what are the local health officials' powers. I think this is the complexity that I've seen during COVID is simply because I've never seen governors involved with public health crises to the extent that they are today. And for governors, they have comprehensive powers. Health officials at the state level can deal with issues of epidemiological investigations, quarantine, notifications, contact tracing, and all that. But only your governor can do things like suspend laws that interfere with the effort, command, the National Guard to assist with the effort, deal with the economic fallout from a pandemic, deal with eviction moratoriums, all the comprehensive things. And then you have the state. And then in my state, our local health departments within their jurisdiction have extensive powers, and they can go further than the governor in mask orders or in stay at home, in prohibition on gatherings and that sort of thing. But it's going to be so state specific.
Yeah, and then I also wondered about the flip side to that. And I at the time, it was Sallie's presentation from earlier about HIPAA and how HIPAA is a floor and not a ceiling. But then there's the public health exception. Is that a similar kind of floor that everyone has to follow, or could governors actually work against public health? As
In terms of data sharing, Melissa?
yeah, I mean, could a governor that a local like public health couldn't issue press releases or couldn't require masks?
I'm sure. For one, typically state public health officers report up to the governor, and HIPAA, as you said, is a floor. And if state law, including governor's executive orders, are more stringent than HIPAA and provide additional privacy protections, then HIPAA would preempt state law. In terms of wearing masks, I think I'll have to defer to Denise and Peter about that.
We've seen that in several states, Georgia and Texas, where the local health officials wanted to, and Arizona, local health officials wanted to go beyond. In the Georgia case, the Atlanta mayor sued the governor, saying the governor did not have the authority. It really will depend on state law for which governmental level has the authority. In Texas, ultimately, and by the way, all of this has to be seen within the political environment. If ever anyone doubted how political public health is, the pandemic has exposed that illusion. And in both the Georgia case and ultimately in Texas, they basically reached a political resolution where the governors backed off and let the locals, and I think Arizona also. I don't think that's a particularly good solution given the transmission of the pandemic, but it's a better resolution than a lot of litigation.
Well, that's great. And we have a chat question specifically about politics that I'd like to get to in just a moment. But Andy Baker White has raised his or her hand. And I've given you, I hope, the opportunity to unmute yourself, Andy, in case you wanted to respond to the conversation that was going on. Or if you have a different question, you can go ahead.
Sorry, can you hear me now?
Yes, we can. Andy, you can go ahead.
Can you hear me now?
Yes, you can go ahead.
He just muted himself.
Okay, there might be a technical glitch. Andy, we were hearing you when you said, can you hear me now? But I wonder if there's a Zoom pathable overlap there that maybe isn't working that well. I noticed earlier today, if I wanted to hear the audio in the pathable window, I had to join audio by computer, leave audio by computer, and join it again, and it came back. So I wonder if it's a weird little glitch like that. But if you want to chat it in your question, that will be fine. Or we can also try one more time if you want to unmute yourself. We can try again to hear your question. Okay, you are unmuted. But I don't think you can hear us. Okay, well, sorry about that. It seemed like a good idea going in, but we'll have to rely on chat. So we have a question from Eric Hendricks about politics in particular. Peter, you were starting to get there, I think, about the politicization of the pandemic and good public health practice. And so he's wondering whether you think that reports of politicization of the CDC guidance and leadership, I'm adding that on my own, has lessened trust in that guidance, and should it?
Yes, and yes. Try not to be partisan here, but for generations, CDC and FDA have been independent, science-based agencies. That's not the case right now. And as a result, you have confusion over masking, confusion over treatment. The plasma example, where clearly FDA was pressured to approve a treatment it knew was at best questionable. And CDC was forced to abandon guidelines that it knew were inadequate, were better than what they were forced to issue. And then most recently, this week, we learned that the sacrosanct MMWR is being edited by people who have no idea about public health, about epidemiology or the transmission of disease. So those are facts, not speculation. It undermines science, it undermines the effectiveness of the CDC, and you can see it in the polling. If the poll recently, do you have faith in the CDC and FDA regarding the availability of a vaccine? In other words, would you take it? And only 44% of the public responded positively. So I think there, and I think it's a potentially damaging. It's potentially damaging to these agencies over the long term. That is, the damage will not just be short term. So I think my view is very much, yes, it has undermined public confidence in those two agencies.
Andy did chat in his question, which I think is pertinent here too, and that is anyone tracking attempts to take authorities away from public health at the state level or governor level public health?
This is Denise. I know that we have two of our regions at the network that put out a judicial report. I know that they have been doing a lot of tracking. I wish one of them was here to give us the details, possibly Kayleen, who's moderating, or who's our assistant here, might be able to, or we could provide a link.
Ask me again, Denise, sorry.
I was thinking of the judicial work that the Network for Public Health Law has been doing, and the tracking opinions and the reporting out of opinions.
Oh, sure. The newsletter, Judicial Trends newsletter.
Yeah.
Is on our website. I'll see if I can post a link to it in the chat.
Okay.
Also, Andy, you might check the law atlas that Scott Burris manages at Temple University. His group may be tracking these issues. I think it's an important question. I hope someone is tracking it. The Mid-States has been contacted by one health department about this very issue, and I'll be looking into it in response over the next couple of weeks. Lance Gable also, again, who presented earlier today from Wayne State University, I think you know him, may have some information also. And I'd be happy to connect you with him. I haven't been tracking it personally. I'll all I've gotten is anecdotal information. At a minimum, I suspect that legislatures may be using this as a cudgel to get public health to back down. My concern, and this goes a little beyond your question, my concern is actually less about COVID-19. Let me revisit. Less about how these legislatures would affect health department's ability to confront COVID-19 than I am about the long-term limitations. In other words, if you write legislation that's restricted to this pandemic, it's bad. It's terrible public policy, but it has a limited time duration. If, however, you write the legislation in a way that it permanently constrains, let's say, Ingham County from issuing quarantines, that's an entirely different matter that fundamentally alters public health authority. That's my real concern about this legislation.
All right. I was giving a pause in case anyone else wanted to jump in. There is a link now in the chat to the Judicial Trends in Public Health. I'd like to also mention that among the many network resources on COVID-19 is an FAQ page and other resources that are on the website under the FAQs. So, Carrie, I wondered if you had a question from the list that we were compiling from those questions and earlier that you might want to tee up.
Sure. Yes, I am unmuted. Along the lines of state and local action, whether through executive orders, public health orders at the state and local level, I recently transitioned to the network from the Michigan Department of Health and Human Services, and enforcement, I will say, is a challenge, and that was something we were seeing as well of reading about it in other states. And I'm just wondering, Denise and Peter and Sallie, what sort of issues you've seen on enforcement and any ideas or creative solutions that states or other jurisdictions might have utilized.
I'm seeing more and more local health departments using civil citations and fines. Those have been used for years in food sanitation, and I believe smoking, secondhand smoke violations and other areas. But until COVID, I have not seen those kind of fines served in by local health departments. Now, the question is, how effective have they been, and how do you get them enforced? I know if I got a penalty of $1,000, I certainly would stand up or sit up and take notice.
So we've had a couple of inquiries about this, one news inquiry and one from a health department. And the issues are complicated because law enforcement doesn't really want to enforce these laws. They're not excited to be giving out citations. In the health department request that we received, the issue was whether the local health department could outsource enforcement and hire representatives of the department to other attorneys or possibly private security to issue citations. And again, we interpreted the undefined language of what constitutes a department representative to say you can do this. But if law enforcement isn't going to do it, then you have to ask, do you have the resources really to enforce this? Or is this just going to have to be a matter of voluntary compliance, ultimately? So earlier today, Patty Freeman gave a really interesting and good description of what's happening in Minnesota. And there and other places, we've seen these large congregants, weddings, parties, etc. I don't know that that's, I mean, are you going to arrest people? Are you going to have law enforcement come in and give citations? I'm dubious. I'm really doubtful, especially given the level of resistance that we've seen in the United States, across states, not just limited to a few states. It's almost everywhere where you have major resistance. How do you overcome that? Then you have to deal with the likely appeals. It's going to be heavy investment of time and resources to try to enforce this. As an alternative, which isn't great, better messaging. We need to do a better job with saying why masks protect both you as the user and others. But this gets to the fundamental problem public health faces. We are a collective endeavor in an era of rampant individualism, with a lot of people who oppose, distrust government, back to Eric's earlier question, distrust government, who are, and there's a lot of disinformation. It's an uphill battle. And you have to have really, without cooperation from law enforcement, I'm not sure I would advise a health officer to spend a lot of time other than on messaging, education, trying to enforce the law.
Thank you. Transitioning to data, a data-related question. We talk a lot about HIPAA and what's permissible to share, but at the federal level, another privacy law that often comes up is 42 CFR Part 2. And SAMHSA waived compliance with Part 2 for SUD treatment providers during the, or did they, as the question, have they waived it, and what is required? So Sallie, I thought we might get your thoughts on that.
Sure. No, SAMHSA has not waived compliance with Part 2. And recently, we received a request for technical assistance asking about Part 2's impact on public health reporting. And as we dove into the question, into the TA, we identified that unlike HIPAA, Part 2 does not have an exception for public health reporting. So what that means is your options are really very limited in terms of having visibility or any kind of surveillance as to what's going on with this population and the impact on this population during the pandemic. So what your choices are is, if you're a Part 2 program, is to share de-identified data with public health, and that might be useful from a population standpoint, but certainly wouldn't provide the granularity that's needed likely in terms of understanding the population around dates and lower level geographies. So you have de-identification. You can share with individual consent, which would be quite a project if you have a large population of individuals that you want to share data around with public health. If you didn't identify that kind of consent when you had all of the other paperwork signed. You would have to approach each individual in a one-off kind of process and get consent. Or you could have a court order, but it would have to, or a subpoena, but it would also have to be tied to some sort of emergency. So we really are very limited in terms of the kind of substance use disorder information that public health receives.
Thank you, Sally. Peter or Denise, do you have any other insights into that? And I'm seeing some body
Sallie
language.
covered it well.
Because I actually have a similar one, and I'd like to point out the time to people. We are in coming into the last 15 minutes, so if you have a specific question or situation you'd like to address, please do go ahead and type it in. Even if it can't be completely addressed today, we'll have it in the TAQ. But I was wondering, from the perspective of data sharing arrangements that aren't necessarily driven by governmental public health powers, where there are maybe data intermediaries like HIEs, which may or may not themselves be covered by HIPAA. There's a lot of different kinds of coalitions going on to promote community information sharing. Sometimes it's health related, sometimes not. So I'm wondering what the implications are if, say, a data sharing coalition does have health information which may or may not come from a HIPAA covered entity, but what their risks are there, but also if they have a relationship with a healthcare entity and a data sharing arrangement which has a very specific use case, would they need to, should they, must they start thinking about creating new data sharing agreements in order to use information in order to help combat the pandemic?
Well, I think I could start, but then I'm sure everybody else will want to chime in. This is an interesting question, Melissa. So you'll want to look at the purpose of the data sharing collaborative. What kind of data are they sharing? What laws regulate the data? What laws regulate the data holder? In the United States, we have a real patchwork of laws based on so many different factors that the first place you start is figuring out those pieces and identifying the laws that impact the individuals, the data holders, and the data, and see how close it is to your new COVID purpose. It could be that the data sharing was already occurring for some other health purpose, and COVID would align with the data sharing that was already identified. If the data sharing required consent, and the collaborative was utilizing consents, you want to take a look at the specific language. It may be that you also want to look at the privacy notices that were given to the individuals at the point of collection. You never want somebody surprised by any kind of additional use of their data. It should be reasonably anticipated by both what's told to the public in terms of transparency with the data notice and with the consent. And I'll pass it on to my other colleagues in case they want to offer their 2 cents on this one too.
I'll just add one point. From a conceptual perspective, the much maligned HIPAA requirement of the minimum necessary data, much maligned because it's undefined, is actually a good way to think about it. What data do you need for the specific purpose? And you shouldn't go beyond that. It's really trying to figure out exactly the data you need for whatever your objective is. The other part of it is, if you've got sensitive data, you need to be overly protective of it. But otherwise, I agree with Sallie entirely.
And I thought of something else while Peter was talking. Peter, your mentioning minimum necessary is excellent. And I heard that concept described in a very different way on an all-in webinar a week or two ago around centering racial equity in data sharing and data integration. And we were hearing from Amy Hahn Nelson, who talked about the work and provided us with a really good background and foundation for data sharing. And she referred to the process of determining what data is minimum necessary as curating data. And she was telling us that individuals who curate data are really far better at sharing data and in working with data with other stakeholders because they have a very clear purpose. They know exactly what data features are needed to answer the question, and they're not essentially trying to boil the ocean, and they're not violating any privacy laws along the way. So I know that that playback is available on the All-In website, and I encourage people to go and listen to it and also to check out her materials. There's some fabulous information there around the basics of data sharing and who is a data steward, who's a data custodian, who's a data owner.
Denise, it looked like you were going to.
I was just unmuting myself to say Sallie and Peter have covered everything. Nothing to add.
All right, great. Well, we have a question coming in from Sanjita asking whether there is a repository of data sharing agreement samples available specifically, I think, at the Network for Public Health Law. We might be able to come up with some others also, including at Amy Hahn Nelson's at the Actionable Intelligence for Social Policy and elsewhere on All In. And she points out that because of the COVID response, a number of data sharing agreements are now involving technology vendors who have developed applications for testing and contact tracing activity and will have access to PII on their servers or databases. And I think actually what that makes me wonder is that make them the data owner of the PII and is a technology vendor, in that case, a HIPAA covered entity.
Wow, I think this question's like an onion that we need to peel layer by layer. So starting at the beginning with a repository of data sharing agreements, the answer is absolutely. So on the network's website, if you look at under health information and data sharing resources, we have a fact sheet that describes data sharing agreements, and we have a lot of different examples. We are also on the All-In platform within our data law affinity group, and if you're not a member, not currently a member, I really hope you'll join. We are starting a data sharing agreement, data use agreement, MOU library. We want to collect as many as we can that are used for different purposes, and I really encourage you to join All In. You can meet a lot of your peers in All In. You can post questions. You can participate in great webinars. Hope you'll do that. So your question around technology vendors. Technology vendors are working through their data sharing agreements are very complicated. I have found that most vendors try to take control of their clients' data by having terms, just as you said, that they become the owner, or that they get to use the data for their own purposes, that they will de-identify the data. And to the extent you can, it's really optimal not to give up that authority, because you never know how, it's often hard to know if they'll truly use the HIPAA safe harbor standard or what standard. The standard is typically not specified. And if your vendor does not do a good job of de-identification, or if they don't actually do the de-identification, or if they own the data, you may see that data pop up somewhere else and then have a complete loss of trust with your with the people that your health department is serving. But it's really hard. A lot of times vendors, technology vendors particularly, will not enter into a contract for you to use their products without giving up that control. So it's a tough issue, tough nut to crack. I'll let others weigh in.
So Peter, Denise, Carrie, do you have any other layers of that onion you'd like to peel back, or?
No.
Okay.
Sallie's the expert, right, Peter?
Yeah, exactly.
Thanks for the good question, Sangeeta. It's a big issue.
All right. Well, I'm going back into some of the TA questions that have the Network for Public Health Law has been collecting. And I think this one might engage you all. The question is, how may health departments share patient-specific COVID-19 information with first responders and law enforcement that both provides the needed information and respects individual privacy?
We can all talk about this one. I've just been talking a bunch. Do one of you want to start, or do you want me to start? Okay, I'll start and you guys can jump in. So HIPAA provides public health, when covered by HIPAA, with a number of exceptions that it can utilize or evaluate when it is posed with a data disclosure question to law enforcement or first responders. Now, first responders, if you know that they have come in contact with someone who is infected with COVID, CDC has added COVID to the list of conditions that it's required that you tell that first responder. Now, if you're looking at data disclosure prospectively to law enforcement and first responders, the Office of Civil Rights put together some really nice guidance that offers a best practice. And what that guidance is, and it's using the public health exception to try to reduce the spread of infection and to control the pandemic. And so what the guidance recommends is that you share the data set of individuals who are COVID positive with dispatch with the first responders, and have a data use agreement with them so that they let their EMS personnel or law enforcement know on a per call basis if they are going out to assist an individual who is COVID positive. It would not be okay for dispatch to share the entire list with the entirety of first responders. So that's one approach. And I know we've had a whole variety of questions, so I'll let others respond too.
I'll just add that this has been an extremely contentious issue in many jurisdictions. At least it was at the beginning of the pandemic. It may have calmed down. It even led to lawsuits against local health departments to require them to reveal information to first responders. The one challenge, and a lot of local health departments found ways to share information, the minimum necessary, to do it in a way that protected as much as possible disclosure so that it was just not generally shared within a police department or law enforcement or other first responder. But the one issue has been how do you tell if somebody is infected? Being reported as a positive case is one thing, but with so many people who are infected who have not been reported as a positive case, it's pretty much an assumption that anybody may be infected. So how is that information helpful? I know it's been very important to first responders to know, but at the end of the day, the question still remains, how will that change your behavior or the steps you take to protect yourself?
I have nothing to add.
I'm going to add one more interesting scenario that we received a request for technical assistance around, and it highlighted that it may be that your health department is requested to share a person's COVID-19 test results with first responders for treatment. It may be that the first responder needs that information so that they can perform appropriate treatment while they are dealing with the individual. So that there are a whole host of different scenarios where it might be appropriate. And so I'd like to point you to a resource that we developed for public health that identifies all of the different HIPAA legal pathways for sharing COVID data within HIPAA. And if you go to our COVID-19 resources and look within that, on that webpage, and then go down to the resource tab and click in there, you'll find it.
Great, thank you. I wonder whether Kayleen might be able to pop in some extra links. Normally, this would be the kind of thing that I would quickly be collecting to put in the chat. But we are at.
I can get it. I'll get it.
Okay, thank you. We are at the last 2 minutes, so I don't know. I'd like to hear maybe a little prognostication about issues that public health attorneys might want to be on the lookout for to take us out of the hour. And then I'll look forward to continuing the conversation with everyone on the All-In Data Law Group. So Denise, do you want to get us started with what you see in an imminent public health law controversy?
I just see continuation of attacks on public health authority and issues around enforcement. There's also, as the pandemic goes on and on and on without an end in sight, issues about how long can our public health officials exercise these extraordinary powers.
Excellent. Peter, what do you think?
I agree, and I think the task of the public health attorneys will be navigating the space between the grant of authority and the need to act with some constraints given the current political environment.
And Sallie, I actually want to ask you more specifically, given the already very complicated data sharing landscape, are emergency powers coming to be under COVID a potentially long-term benefit, or do they also have pitfalls to be careful about?
Probably all of the above. You don't see a lot of emergency power with respect to data sharing except on the federal level. The HHS Secretary has issued several waivers and notifications of enforcement discretion that have impacted application and/or enforcement of HIPAA. On a state level, I have not seen that as much. I think I would be concerned if I started to see a lot of action at that level. I just haven't seen that done. So I don't think huge impact from a data standpoint on public health in terms of emergency powers.
Well, great. Thank you all very much. And thank you for letting me sit in on this session and hear you discuss some of these really interesting issues. Thanks everyone who joined us and contributed your questions and thoughts. Again, I hope that you've been enjoying this conference. Thank you very much for the network for moving ahead with a virtual convening. And if you enjoy virtual convenings and what I sometimes call asynchronous multimodal communications. Again, please feel free to check out community.allindata.org and some of the online forums we have there to dig into these issues a bit more. With that, I will thank you all. Please do take the survey, the evaluation survey. It'll remain up throughout the event, but if you take it now, it'll be fresh on your mind, and enjoy the rest of the conference. Thank you.
Thanks, everyone. Bye.
Bye-bye.